In New York City, nearly 1 million tenants living in rent-stabilized apartments received a notice last fall. Their rent was going up again, for the fourth consecutive year in a row. At the same time, thousands of those same buildings are now silently moving toward foreclosure. And in the market-rate rental sector, a sweeping new law that was supposed to save tenants money is instead being absorbed into higher monthly rents. This is a story about a housing system under pressure from multiple directions at once, and about millions of renters who don't fully understand what the laws that govern their homes actually say. According to the New York State Division of Housing and Community Renewal, roughly 2.3 million apartments exist across New York City. Of those, nearly 1 million are rent-stabilized. These units are concentrated in buildings with 6 or more units constructed between 1947 and 1974, along with some newer properties that receive tax incentives. Rent stabilization limits how much a landlord can raise rent each year, requires lease renewal offers, and restricts the conditions under which a tenant can be removed. For decades, these protections have served as the foundation of housing affordability for lower and middle-income residents across all 5 boroughs. The rules governing annual increases for rent-stabilized units are set by the New York City Rent Guidelines Board, a 9-member body appointed by the mayor. In the spring of 2025, the board voted on what are called Order 57 guidelines, covering all rent-stabilized leases that begin between October 1, 2025 and September 30, 2026. Under those guidelines, landlords may increase rent by between 1.75% and 4.75% on one-year lease renewals, and between 3.75% and 7.75% on two-year renewals. These are not fixed numbers. The board sets a range, and landlords can apply for increases within that range depending on specific building conditions. For context, the board estimates that operating costs for rent-stabilized buildings rose approximately 6.3% over the past year. That means even at the high end of the approved range, landlords of stabilized buildings are not keeping pace with their expenses. Property taxes, water and sewer rates, insurance, labor and maintenance costs have all increased. Heating fuel costs remain volatile. These buildings, many of them aging structures that predate modern construction standards, require ongoing investment that the current regulatory structure makes increasingly difficult to finance. The foundation of this entire system was reshaped in 2019, when the state legislature passed the Housing Stability and Tenant Protection Act, commonly referred to as the HSTPA. That law made several significant changes. It eliminated the vacancy bonus, which had previously allowed landlords to increase rent by up to 20% when a long-term tenant left and a new one moved in. It also made it substantially harder to remove units from rent stabilization entirely. Before 2019, landlords could exit the stabilization system either by performing extensive renovations or by reaching a certain rent threshold. Both of those pathways were effectively closed or severely restricted by the 2019 legislation. The consequences of the 2019 law are now surfacing in the credit markets. Many owners of rent-stabilized buildings originally financed their properties with loans that were underwritten, under the assumption that deregulation was possible. That revenue from a certain number of units would eventually rise to market rate, making the loans repayable. That assumption is no longer valid. As those loans mature, lenders and borrowers are discovering that the underlying income projections no longer hold. According to reporting by City and State New York, as of April 2025, over 2,000 rent-stabilized units in New York City are in danger of defaulting on their mortgages. In 2022, 176 units were foreclosed upon. That number has doubled approximately every year since. The Rent Guidelines Board itself has stated that an estimated 10% of rent-stabilized units now operate at a loss for their owners. This matters directly to tenants. When a building enters foreclosure proceedings, the outcome is uncertain. Banks that foreclose do not always find buyers willing to maintain the property. Buildings can fall into disrepair. In some scenarios, tenants face displacement, not through eviction, but through deteriorating conditions. The real estate lobby has called on state lawmakers to revisit the 2019 legislation, arguing that structural reform is necessary to prevent a broader collapse. Tenant advocates and progressive legislators oppose any rollback of the 2019 protections. As of early 2026, both the state legislature and the city are approaching an election cycle, and no significant legislative resolution appears imminent. Separate from the rent-stabilized sector, 2024 and 2025 brought major changes to the market rate rental landscape as well. The Good Cause Eviction Law, which took effect on April 2024, extended a new layer of protection to tenants in unregulated apartments. Prior to this law, landlords in the market rate sector could decline to renew a lease for any reason, or raise rent by any amount, as long as they provided appropriate notice. Good Cause Eviction changed that by requiring landlords to have a legally recognized reason to end a tenancy, and by establishing what the law calls a local rent standard, a threshold above which a rent increase is considered presumptively unreasonable. As of early 2025, that standard in New York City stands at 8.79%, calculated as 5% plus the current rate of inflation, or 10%, whichever is lower. An increase above that level can be challenged by a tenant in housing court if the landlord subsequently attempts to evict for non-payment. The law covers tenants in market rate units who rent from landlords owning more than one rental unit statewide and who pay less than 345% of the fair market rent, which works out to approximately $4,900 per month for a one-bedroom in New York City, as of current figures. There are significant exemptions. The law does not cover units built after 2009. It does not cover owner-occupied buildings with fewer than 11 units. It does not cover co-ops, condominiums, units tied to employment agreements, manufactured homes, or any property already covered by rent stabilization or another subsidy program. Tenants who live outside New York City are covered only if their municipality has opted in. As of April 2025, the cities of Albany, Beacon, Binghamton, Catskill, Croton-on-Hudson, Fishkill, Hudson, Ithaca, Kingston, New Paltz, Newburgh, Nyack, Poughkeepsie, and Rochester have all adopted the Good Cause framework. The law is enforced through housing court, not through a dedicated agency, which means tenants must raise it as a defense during an eviction proceeding rather than filing a proactive complaint. On June 11, 2025, a second major reform took effect in the market rate sector. The Fairness in Apartment Rental Expenses Act, the FAIR Act, prohibited landlords from requiring tenants to pay broker fees when the broker was hired by the landlord. Prior to this law, New York City had been one of the only major rental markets in the country where tenants routinely paid fees of 1 month's rent or more to brokers who were acting on behalf of the building owner. According to StreetEasy, the average upfront cost to sign a lease in New York City in 2024 was approximately $12,951, with broker fees comprising a substantial portion of that figure. The FAIR Act was passed by the City Council with a veto-proof majority of 42 out of 51 votes, and became law in December 2024, after Mayor Eric Adams neither signed nor vetoed it within the required period. The law was challenged in court by the Real Estate Board of New York, which argued it infringed on commercial free speech and was preempted by state law. A lower court upheld the legislation, and a request for a stay pending appeal was denied. The law is currently in full effect. Violations carry fines of up to $2,000 per instance, and tenants may also sue privately to recover any illegally collected fees. Enforcement is handled by the Department of Consumer and Worker Protection through hearings at the Office of Administrative Trials and Hearings. The immediate market reaction to the FAIR Act included a brief dip in available listings, followed by stabilization. According to StreetEasy, listings that had previously charged tenant-paid broker fees saw an average annualized rent increase of approximately 5.3% in the months following the law's implementation, a figure that some analysts note effectively absorbs the cost of the broker fee into the monthly rent over time. In Staten Island, median rents rose 16.4% year-over-year as of October 2025, reaching $3,200 per month, the steepest increase among all 5 boroughs. Citywide median rent rose 8.2% over the same period. Landlords are permitted to adjust rents on new leases to account for broker costs they now absorb directly, but rent-stabilized units remain subject to the guidelines established by the Rent Guidelines Board regardless of the FAIR Act. Beyond Good Cause and the FAIR Act, the 2019 HSTPA established several additional protections that remain in effect and are worth understanding. Application fees are capped at $20. Security deposits are limited to 1 month's rent. Landlords can no longer require last month's rent as part of the move-in deposit. Notice periods before eviction were extended and formalized, landlords must provide a 5-day notice of late payment, followed by a 14-day notice to pay or vacate before filing any court proceeding. For lease non-renewals, the required notice period is 30, 60, or 90 days depending on how long the tenant has occupied the unit. A new 2025 law further limits charges for bounced checks to no more than what the landlord's bank actually charged, removing the ability to treat banking fees as an additional revenue source. A right to counsel law is currently in the process of being finalized in New York, which would provide free legal representation to low-income tenants facing eviction. Housing advocates have long argued that the imbalance between represented landlords and unrepresented tenants in housing court is a structural problem that undermines whatever formal protections the law provides. Under good cause eviction, for example, a tenant must raise the law as an active defense during a court proceeding. A tenant who is unaware of the protection, or who lacks representation, may lose a case that the law was designed to prevent. The right to counsel expansion is intended to address that gap, but its full implementation timeline remains pending. For tenants across New York State, whether in stabilized units, market-rate apartments, or cities that have opted into the good cause framework, understanding the current landscape requires attention to multiple overlapping systems. Rent stabilization governs roughly half of all New York City rentals. Good cause eviction now covers much of the market-rate sector. The FAIR Act reshaped broker relationships citywide, and an underlying structural tension between operating costs, regulated rents, and aging building stock is generating foreclosure pressure that has not yet produced a legislative response. State officials, including Governor Kathy Hochul, have acknowledged the affordability pressures facing both tenants and building owners, but no comprehensive legislative package has been announced. The 2026 state legislative session will unfold against a backdrop of both a significant budget gap and an election calendar that makes politically costly trade-offs more difficult to advance. Further developments in the rent-stabilized foreclosure situation, the status of good cause opt-ins by additional municipalities, and the outcome of ongoing litigation related to the FAIR Act are all expected as more information becomes available.